the heck does that even mean? Ooh, I said heck. What does heck mean? Where did heck come from?
To avoid saying hell, I suppose.
And why the heck am I talking about heck? No question, it's a difficult economic period right now, and employers have to react. And from a human resources perspective, that reaction can involve a number of different approaches, but certainly one of them is to say, look, we got to make changes to certain terms of our employee arrangements, as it were. Sometimes it means we're going to change duties and responsibilities. Sometimes it means reporting structures. Sometimes it even means compensation, changing commission plans, for example, or bonus plans. So the challenge with that is, am I in a position as an employer to legally, in effect, make these changes that are not advantageous to the employee? If you've contemplated it in your employment agreement, then in all likelihood you can. I mean, there are nuances to that, degrees of change, but nonetheless you can contemplate for it. If it's not in the agreement, though, or it's not drafted properly, you end up in a situation where, as an employer, you can't make unilateral changes that disadvantage the employee. So how do you do it? So the way you do it is you cut a new deal. You cut a new deal with the employee and you say, here's what I'd like to do as the employer. I know it's less advantageous to you, but, and here's the real key, I'm going to give you something in exchange for your agreeing to it. It's called legal consideration, something of value in exchange. Now, the key element to legal consideration is it doesn't have to be anything in particular. In fact, the courts don't even look at what's called the sufficiency of the consideration. It's whatever the employee ultimately agrees to. It could be minimal, like including chiropractic care in the benefit plan. It could be adding another week of vacation. It could be anything. And in fact, sometimes you have this in sort of legal theory at law school. It can be an acorn. In other words, the employee likes the acorn. Fantastic. The employee gets the acorn, as it were, and the employee agrees to these less advantageous terms. Of course, you're not in practice going to use an acorn. So, but here's where employers sometimes trip up. Employers will say, my legal consideration is the 1% raise that I was otherwise going to give, let's say starting January 1st. So I'll use that as my legal consideration, and then I'll cut this new deal with the employee with less advantageous terms. You can't do that as an employer. Why? Because you would have provided it anyways. Mm-hmm. It has to be something you would have not otherwise provided to the employee. So you have to bear that in mind. It has to be voluntary, but once again, it can almost be anything to constitute that legal consideration, and then you can cut the new deal with the employee. Was I saying what the heck are we talking about, Bobbies? I don't know what the heck I was saying.